Disputes are an inevitable part of life. How you choose to approach and deal with them can make the difference between becoming consumed by conflict or finding a solution that allows you to move on. When a dispute becomes deadlocked, the parties involved will often think the only answer is to take the legal route, involving courts, barristers and solicitors. Mediation offers an alternative path that can lead to better outcomes for everyone. How? Well, mediation is quicker, cheaper and much less stressful than a protracted legal battle. 80% of mediations end in an agreement, or at least with the issues clarified, so as to make the dispute easier for lawyers to deal with. Most importantly, mediation gives you far greater control over your own negotiations. It offers the opportunity for an agreement that's reached by you, rather than a decision that's handed down by a judge. The mediation process is structured, but a lot less formal than a trial. The mediator is not a judge, but acts more like an umpire or referee, keeping the discussions on track and moving forwards. They play an active role, but they are entirely neutral and unbiased. The mediator intervenes to test both sides of the dispute, as well as to explore options and make suggestions. Mediation allows the parties in dispute to negotiate directly with each other, unlike in a court where all communication has to go through lawyers who speak to the judge on your behalf. So the mediation process creates an environment that is more open and frank, leading to more meaningful and constructive discussions. It's suitable for all types of dispute, whether personal, such as divorce, boundary or probate disputes, or in business, such as shareholder, partnership or employment disputes. Litigation, on the other hand, is adversarial, making it much harder to have a constructive dialogue, or often any dialogue at all. Mediation is about seeking common ground and finding a solution that is acceptable and workable for all parties, whereas litigation is about winning points in a legal tug-of-war. Successful mediation ends in a settlement agreement, which can form the basis of something more legally binding. Litigation typically takes just a single day, with the cost shared between parties, making it much cheaper than lengthy litigation, in which each party pays for their own separate legal representation. And mediation is completely voluntary. Nobody can be forced to take part. So agreeing to mediation is the first positive step towards reaching a solution that is acceptable to everyone. Crucially, mediation has been proved to work in 4 out of 5 cases, leading to an agreement or at least a useful clarification of the issues in dispute. That's why the courts are increasingly encouraging parties in dispute to explore it as a possible option before and even after starting down the litigation route. Wimster's mediation offers a professional yet personal service that is fair, impartial and effective. Please get in touch if you would like to find out more about mediation and how it could help you resolve your dispute.